Advertisements are everywhere. They shape our desires, fuel our decisions, and colour our perceptions of the world. Every day we're bombarded with promises of something better. Better products, better lives, better futures. But beneath those slogans and glossy images, there lies a deeper question. How much weight do we place in the words we see and hear? This is the story of how a simple promise made in a single advertisement would spark a legal firestorm that would forever change the way companies communicate with their customers. Hello everyone, welcome back. My name is Oscar, and today we're going to be exploring a strange case that absolutely shaped advertising forever. So for a bit of info about me, I have graduated from a law degree from a top UK university, and this channel is all about sharing valuable insights into law and culture. Coming across this case around 2 years ago now, it's only really dawned upon me how significant this case is, and the case is called this: Carlill versus Carbolic Smoke Ball. And this case happened centuries ago. I believe it's 1893 that the case took place. It's truly surprising how it happened so many centuries ago, but how it still continues to have a massive impact in UK culture within the advertisement and contractual industries. So let's begin with the strange tale. It's a very interesting case, to say the least. So it all began in the winter of 1891, and at this time London was on edge. With the recent passing of the 1889 pandemic, it was still very much in the memory of everyone, where millions of lives were lost. Some people assumed it was influenza, but it could have been literally anything. A lot of people thought it was something much more deadlier. And it was during this time that people were very, very desperate for protection. And within this fear-stricken world in England, in stepped the Carbolic Smoke Ball Company, and they made a very bold promise to everyone. So their product, the Carbolic Smoke Ball, was a very interesting contraption. So in essence, it was a rubber ball filled with carbolic acid, attached with a tube that was supposed to be inserted into the nose. So in essence, by squeezing the ball, this would release sharp vapours. And the company claimed that this could apparently ward off influenza and other illnesses such as the common cold and flus. But this is where it gets really interesting. The company didn't just promote their smoke ball. What they did, they made a wager with the public. So the big question is, what did the ads say? So just have a quick look at it now. The ads were dated on the 13th of November 1891, and they were truly striking because what they promised was £100. This was worth about £14,000 today to anyone who contracted influenza after using their smoke ball, according to the printed instructions, of course. But the company went even further. What they did, they boasted a deposit of £1,000 in their Allianz Bank to really show their sincerity and how far they're willing to go to prove that they're not lying and this is a true thing that they're trying to do. And it wasn't just a product that they were selling. It was in essence confidence wrapped with bold guarantees. And so obviously the public took notice of this. And the company also had a lot of evidence to back their claims, because apparently in the last epidemic, thousands of smoke balls were sold and they actually cured influenza in the many cases that were reported. And there was no reported cases of any illnesses directly due to the smoke ball. So I would assume everything sounded perfect and fine on the surface levels. And this was absolutely crazy at the time, because when you think about this was only getting sold, the smoke ball was getting sold for 10 shillings. And if it actually cures this remedy, it's got to be one of the cheapest options in the world of curing illnesses such as influenza at the time. So enter Louisa Elizabeth Carlill. So she was one of the many people that saw the advertisements and decided to try the smoke ball. She purchased one and she followed the instructions perfectly, which was to use the smoke ball 3 times a day for 2 months. Even though she did follow it, on January the 17th, 1892, she did unfortunately fall ill with influenza. So as you would expect, she was furious, so she wanted the £100 reward that they promised. So her husband, who was a solicitor in fact, he wrote 2 letters on behalf of Louisa to the company, but these were just completely ignored. So after he was ignored twice, he actually wrote one more time And the company actually responded, and they did something very weird. So the company said that to prevent fraud, she had to in fact go to the company's office and use the smoke ball daily, which was extraordinarily interesting, and it wasn't in the original advertisement. So she was obviously absolutely fuming at this time. So what she did was take the company to court. Her argument was simple but groundbreaking in court. She said that the advertisement wasn't just puffery, it was a legally binding offer. By buying and using the product as instructed, she has accepted the offer, so therefore they must pay the £100 reward in return. So obviously the company disagreed with this, and in court their argument was this. It was simply that their advertisement wasn't a strict legally binding offer. Instead, it just simply was a clever marketing ploy. Therefore, no contract existed, so she couldn't claim that there was a breach of contract when the contract didn't exist in the first place. So that was their argument. So when the court came to looking at all the evidence, there was 6 key points that I'll quickly explain that they had to analyse. The first was that, was it really a mere puff, or was it a legally binding offer? But I think the main point is the fact that the company placed in their bank £1,000 really does show the seriousness of the undertaking. The second point was to do with the data. If it's too vague, it is unenforceable. Was the data vague? I would beg to differ. It was very clear what to do. It says for the smoke ball to take 3 times a day for a period of 2 weeks to over a couple of months. This is in no way vague. The third point they had to consider was this idea of an offer to the world. Something like this is obviously not an offer. The company isn't forming a binding contract with everyone in the world by saying this. It's only with the people that accept the offer that the company are presenting. The third, and this is something that is specific to contract law, this is the application of the objective test, and that is, what would the reasonable person do? The courts won't necessarily be sympathetic to the company in this scenario. The fifth point, which is much more of an argument that you can develop now rather than later, but that is this. During the time, the industry is a lot more unregulated, so it'd be much more harder to identify whether Louisa was in fact using the smoke ball or not. It's simply down to word of mouth. And the sixth point is much more from a policy perspective, in that if the courts didn't pay Carlill, this would in fact be a major problem because it undermines the whole point of a contract. So in court, this is the result. They found Carlill's arguments very compelling, and they came to the conclusion that it was in fact a unilateral offer that the company made. And this is simply a public promise that anyone could accept for fulfilling the terms of the contract. So the court ordered that the company should pay her the £100 reward. And this wasn't just a win for Carlill, this had a massive effect. This was a legal milestone within the contract arena because it massively shaped how offers, acceptances and contracts are formulated in England. And this really shapes how businesses and consumers interact to this day.